Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in lovely Peckville, Pennsylvania, and I am right here with you each and every week at this time on this station to bring you, the landowner, the information you need regarding natural gas development here in Pennsylvania. Oh, and by the way, I, Doug Clark, have not, do not, and will not represent gas or pipeline companies. I represent the Pennsylvania royalty owner, Pennsylvania landowner. For any and all items related to natural gas here in Pennsylvania, including but not limited to gas lease negotiations, pipeline negotiations, water line agreements, royalty deduction issues, unitization issues, estate planning, gas lease amendments and modifications, multi-unit well consents, surface use agreements, meter sites, compressor sites, you name it. Related to natural gas development in Pennsylvania, buying, selling gas rights, give us a call. Call the Clark Law Firm. See if I can help you. And also, so you're aware, I represent all of my clients. No one else in the office but me. So regardless of your physical location, whether you're located in the western part of the state, the northern part of the state, southwestern, whether you have property in Pennsylvania and you're located anywhere in the country or even beyond, give us a call. See if I can help you learn about our review and consultation services and all other services. Give us a call. Visit the websites, pagasleaseattorney.com, pipelineattorney.com. Even if you're not looking for representation, but you want information, go to the websites. We need to raise the bar for everybody. So check out the websites. Keep listening to the show. When you're ready, you need representation, you want to do a review and consultation, you want to see if we can help you, call the office, 570-307-0702. That's 570-307-0702. And make sure you keep listening each and every week to All Things Marcellus, because I've been doing the show since 2010 and I'm not stopping. We're not stopping. There's too much information we need to get out there. Okay, I'm going to jump right into this. And this show, I say all the time, I try to pick subjects that, even though maybe dedicated to a certain area or maybe about gas leasing and you're interested in pipelines, or I may do a show about pipelines and you're interested in gas leasing. I really try to convey in these shows to understand that even though this may not be the exact issue that you're dealing with now or that you may ever deal with, it gives you an insight as to how these contracts can be applied going forward in a way that the landowner never anticipated or ever thought possible. So the idea is if you can see and you hear the show and you research and you hear things and you can see in this example how a contract can operate really to a great detriment of a landowner, then you can imagine that, hey, it's not just one contract that works that way. These contracts are drafted by very, very smart people working for the company, smart attorneys working for the company, designed to benefit the company. It's that simple. I mean, it's that simple. And some of them are designed to benefit the company in an enormous way. I always talk to people. I say, look, I do these reviews and consultations. I've seen so many forms of gas leases, so many types of pipeline right-of-way agreements. I have worked on, consulted with, negotiated pipeline agreements with over 70 different companies in Pennsylvania to give you an idea of how many lease forms that I've seen. And so when you see these lease forms, you have an idea of, okay, well, this is a very aggressive form in favor of the company. Or, hey, of all the leases I see, this is one of the most even-handed leases or one of the most even-handed right-of-way agreements. And that's just really, really basic. And then I can say, hey, here is where this lease is odd, or this is where this pipeline right-of-way agreement is odd, that you usually don't see this language in an agreement. Sometimes I'll say, I have reviewed many, many leases or many, many pipeline agreements, and I've never seen this type of language. And usually there's a reason why that company is putting it in there. So we need to address that. And that's just basic stuff. However, if it's the first time you're ever seeing it, because you haven't looked at dozens of gas lease forms, you haven't looked at 50, 60 plus pipeline right-of-way agreement forms, different forms. Forms meaning the documents that they present to you, you don't realize you have nothing to compare it to. You're doing this in, I often say, in a vacuum of your situation. And whenever there is so much information available and you have the access to tap into that information, to learn from the mistakes of others, to learn and progress from negotiations of the past, to make sure that you're doing the best you can in your situation while considering what other people around you have been able to do, what other people in other areas have been able to do, what this company has done in the past, and having the ability to communicate with somebody who has that experience, whose total job is to benefit you, to help you, to use all of that experience, past experience, to benefit you. Not somebody who is working for the company to benefit the company. You want to have somebody who, and I'll keep talking about them, just as an example, the review and consultation, where I go through and I break down the agreement and I explain, here are the good, here are the bad, here are the potential loopholes. Here is where this agreement is more aggressive in favor of the companies than almost every other agreement I see. And we talk about that, and we talk about why that may be. How important is this term or this language, and can you change it? And if you can't change it, is it something that you can live with and still proceed forward? So those are the types of evaluations and so much more that we talk about in reviews and consultations. So I talk about them all the time because they have proven to be so valuable. So I'll say again, and I'll keep saying, regardless of where you are in the state, I do these reviews and consultations in office, and I also do them by telephone. We do them, if you have people in different parts of the state or even different parts of the country, we can call in and we do a group call. We can have multiple people on the line, and I will go through this information. I will explain it to you, and I can promise you, my only goal is to make sure that you do the best you can to your benefit. I have no goal at all to benefit the company. None at all. To benefit you. That's my goal. So I really encourage you guys, if you have any type of an agreement, first I negotiate, I do everything, but start, if you want, start with a review and consultation. It's a great way to begin. And I say, look, some ways it's almost like, if you think you may want to go forward, it's like a job interview. If you think that you have a review and consultation and say, boy, this guy doesn't know what he's talking about, I don't want to hire him to go forward anymore, well, then you can say, okay, I'm going to end this. In the worst case scenario, you probably spent 1 to 2 hours of time and 1 to 2 hours of legal fees. However, I'll be honest, I haven't had that happen yet, but maybe it will, but I don't think so, because I do these all the time and I know how they go. So I won't keep pounding this in this show today, but again, I'm always going to encourage you, give the office a call, learn about reviews and consultations, other representation, see if we're right for you. Don't worry about distance. And I can guarantee you this. I always say to my clients, look, I can't guarantee you a certain result, but I can tell you this. I'm going to guarantee you I'm going to be honest, and I'm going to give you my best efforts in everything I do. And that's the best guarantee I think I can give anyone, and that's what I live by. So give us a call, 570-307-0702. Again, that's 570-307-0702. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me each and every week at this time on this station for All Things Marcellus, and let's get into it. Now, this show's interesting, and this is to me just a great illustration about learning from the past. If you regularly listen to the show, or if you have property or reside in Tioga County, you are aware that, and I've talked about it all the time, that there are at last count, and that was a little while ago, but there might even be more, 175 wells as of, I think it was last summer, that SWEPI, which is a company who's active in Tioga County, a subsidiary of Shell, that they have these wells that they've drilled and placed in what's called regulatory inactive status, which is essentially saying that the company doesn't plan to produce from that well for 5 years. Those, again, 175 wells at the last time I checked. So let's be nice. Let's just say there's 100 and some. There's almost 200 the last time I checked, but let's say there's 100 and some wells that are placed in this regulatory inactive status. By the company did this, by the company. So many of these wells are simply vertical wells that are drilled straight down into the ground, vertical from the surface of the earth straight down. They do not turn and go out horizontally to parallel the surface of the earth. They just go straight down. So you drill a hole straight down into the ground. In these cases, in a lot of them, the company will then cap it or shut it in so no gas is coming out. Many of these cases, there are no pipelines connected to these wells, but they drill a vertical hole, they cap it, and they create a unit of production or proposed production that they intend to develop in the future. So you drill, let's say, one vertical hole, but then you designate, it's called designating or declaring a pooling unit. So with one vertical hole, what you will see is companies across Pennsylvania will, especially in Tioga and some western part of the state as well, they'll drill a vertical hole and then they will unitize 600 or more acres into a unit. Now that 600 is not a magical number, it's just a common, smaller unit size, 600 acres. So it might be 500, it might be 700, it might be any other number around those. So they drill a vertical hole and then they create this unit of, say, we'll just use 700 or 600 acres. Well, what that means is because they have drilled this hole and they have designated a production unit that includes 600 acres, then we're going to say that they have put a cap on the well and they have what's called shut in the well, so no gas is coming out. So now what that does for the company is, for all the acreage that is within that 600 acre unit, typically those leases are now held by that one single vertical well. So again, in Tioga County, where in my experience is by far the most rampant, you have vertical holes drilled on one person's property. Then they designate a unit. Say that person has a 50-acre property. They then include another 550 acres and create this large unit, and they hold on to all of the leases that have any property in the unit. And then they go to the next, they move over to the east or to the west, and they do the same thing. So they drill a series of vertical holes, and say if you have two vertical holes, again, straight down holes, and now the first one holds 600 acres. Let's say the second one does the same thing. So for two vertical holes, you're now holding 1,200 acres. You drill four of them, you're holding, in my example, 2,400 acres, and so on and so on and so on. So SWEPI has drilled vertical holes and is holding massive amounts of property. I mean, thousands upon thousands upon thousands upon thousands and thousands of acres by virtue of these vertical holes, which are subsequently capped and shut in and not producing. And as you know, if you listen to this show, I am myself, me personally, I'm disgusted by this. That's my opinion. The whole show is always my opinion. It's an opinion show. It is so disappointing to me to see this occur, because I see in other areas where there is a lot of production, especially in Susquehanna County. And you don't, in my experience, you don't see it just done where there's just so many of these wells like this as I see in Tioga County. I don't see that anywhere else. So if you listen, you know if there's one thing I want to get done, it's stopping this, because it's not right for all the people. It's fundamentally not right in my opinion. Now, the company may argue that it's legal. Well, we'll see about that. Or not so much legal, but authorized under the contract. Not legal, but whether it's authorized under the contract. So we're gonna do something. I'm going to do something, and we're in the process. And so you'll hear me say, and I'll say it's a good time to say it now, if you're in Tioga County and you're being held by a shut-in provision, or your well is a vertical well has been drilled, and you've been in this shut-in phase where you're receiving these shut-in checks. And what I see a lot is wells that were drilled by East Resources and then subsequently SWEPI in the time frame of around 2010 and some into 2011, but a lot were drilled in 2010. So what happens is that if your lease was expiring in 2010, they drill a vertical hole on a neighboring property, create a large 600-acre unit based on a vertical hole, and include a portion of your property in that unit. And if you're listening to this and you're in Tioga County, there's a good chance that you know what I'm talking about, or you have friends that know what I'm talking about. So if your lease was expiring in 2010, they drilled a well, they shut it in, and now they start paying you shut-in payments each year. So your lease would have otherwise expired had they not drilled a vertical hole and encompassed this large amount of acreage. And in many cases, they drill it right before your lease was going to expire. So now they're holding your lease by a vertical well that is shut in. And if your lease is going to expire in 2010 and they drilled it in 2010, they started paying shut-in payments in 2011, and you know who you are. You keep getting yearly shut-in payments, or year after year shut-in payments. So you're in shut-in year 8, maybe even 9, maybe 7, depending on your scenario. But that's too long, in my opinion. That's too long. Now, the companies will take a position that they can do that forever. Well, I don't think that's true. And so we're going to do something, and we're going to challenge that and do something about it, or seek to do something about it. And we're already starting this process. So if you are, and I'm looking for more people, we want to do something about this. If you are in a position, and especially in Tioga County, if you have a property that is held solely by a vertical well that has been shut in for 8 years or more, and you have over 100 acres, I would love to hear from you. I encourage you, give us a call, 570-307-0702. I would like to review your lease and give you, and again, this particular issue. If you have shut in for 8 years or more, and you have 100 acres or more, I would like to review your lease and give you my free opinion as to whether I think you have a claim, whether that is a claim that I would be interested in pursuing. And then also, obviously, it's entirely your choice. You don't have to do anything. So I would like to hear from you. If you know anyone in that situation, you're in that situation, there's no obligation of any kind. I'm telling you, I really want to break this up so bad. And many times people have potential claims and just are unaware of it. So that's why I really want to hear from you, and then I'll explain to you. If we think you have a claim, we'll talk. I'll explain why I think you have a claim, the strength of the claim, and what your options are, and you decide whatever you want to do. And you can say, hey, Doug Clark, thanks for the information, but I'm just going to keep going the way I am, and that's okay. I'm not going to be mad at you. That's all right. I'm still here. If I can help you in any way in the future, I'm here to help you. But I want to make sure that anybody that has a claim who could maybe end their lease, because I totally believe that some people can terminate their leases and have no idea about it, because I see it. I do these reviews. So if you have a couple hundred acres and you can get out of your lease and you can sign a new lease, let's say for $2,000 an acre, well, guys, that's $400,000. That's $400,000. Now, I'm not saying that that's going to happen, but I'm saying figure it out. Let's figure it out. Can it happen? So again, in that scenario, shut in 8 years or more, vertical well, 100 acres or more, give the office a call. I need you to send in your lease, and we'll look up the drilling records. And if you have any other information that's relevant, we'll ask, and we'll ask for that as well. And for that particular service is a free review. Now, reviews and consultations are different, but they usually only take an hour or two. But we need to stop this. And so I really want to hear from everybody. I do these a lot on the weekends and the evenings. I'm committed to this. I really am, because it may sound crazy, but I think when something's wrong, we need to do something about it. All right, when we get back, so I'm telling you about this shut-in in Tioga County. I'm about to go through a lease that's being offered right now in Potter County, which is right next door to Tioga, right to the west. And this lease has all the trappings of giving the company the same ability to do what Shell and what Sweppy is doing in Tioga County right now. And I'm really concerned about this, and I'm going to tell you why, and I'm going to explain what the problem is. And so people are aware of it. And we want to make sure we get this information out, that you're aware of it. Now, you may want to sign anyway, and that's fine. But you sign with knowledge. So this is, I think, going to be really interesting. Stick with me. I'm going to explain it all right after this break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. And in case you forgot, I have not, do not, and will not represent gas or pipeline companies. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me each and every week at this time on this station. Give us a call, learn about representation services, learn about reviews and consultations. 570-307-0702. Again, regardless of your location, give us a call and see what the services are and see if we can help you. So 570-307-0702. Love to hear from you. And if we don't hear from you, keep listening. Remember, the radio show is always general information, my opinions, not specific legal advice. Also, go to the websites, pagasleaseattorney.com, pipelineattorney.com. Check out the websites. Great information there. Even if you're not looking for representation, go check it out. And remember, this has become much more specialized than it was before, in my opinion. You need, if I'm not representing you, if you're not calling me, I mean this, please call somebody who's going to work for you, whose whole goal is to help you, who knows what they are doing. I do this every day, and I learn things all the time. Make sure the person you're talking to doesn't do this. It doesn't have like one or two files, but they really know what they are doing, because this stuff is complicated. And let me explain. So, I talked in the first segment. In Tioga County, it is unfortunately extremely common to have a vertical well that's drilled straight down, and then the company, in most cases Sweppy, they go ahead and they unitize a large amount of acreage. We're using the example of 600 today. This is an example. Could be larger, could be smaller, could be larger. But we're going to say they drill a vertical hole down to Marcellus usually, and they then unitize, we'll say 600 acres, could be more. So what happens is then they go and they drill another well, and they unitize another 600, and so on and so on and so on. So they unitize, 10,000 plus acres by these vertical holes. Then they cap them. And so they drill the vertical holes. So if you had a 5-year lease or a 10-year lease, they drill the vertical holes often right before your lease was going to expire. The reason, so they don't lose the lease. So they drill a vertical hole and they unitize 600 acres. And if any of your leased acres are within that unit, or any of the units that they've created from these vertical holes, you're now held under that vertical well, which means when that vertical well was capped and is not connected to a pipeline and not producing gas, that vertical well is not paying royalties. You're now in your shut-in phase. Now, let me explain something here. If you sign a 5-year gas lease, and in year 1, the company drills a vertical hole and caps it and doesn't produce gas, and say it's not even connected to a pipeline, shut-in doesn't start right when that well is capped. It starts, shut-in does not start until the end of your 5-year, what's called the primary term of your lease. So if you have a 5-year lease and they drill a vertical hole and cap it in year 1, you don't enter shut-in phase until the 5th year, until the end of the lease. Now you have a well drilled, 5 years has expired, so if they didn't drill a well, your lease would have ended. But since they did, and they're not producing gas, you've now transitioned into shut-in. So shut-in doesn't start until the end of that 5-year term or 10-year term. So that's just important to know. But many people in Tioga County had their 5 or 10-year term ended in 2010, and that well was drilled, the vertical well, right before or months before their lease was about to terminate. So now they were receiving year after year these very small, $1 typically to $5 per acre as a yearly shut-in payment. No royalty. So imagine if you have 100 acres, well, if it's $5 an acre, you're going to get $500 a year. Well, you were thinking you were going to be getting royalties, not just a yearly check of $500 for who knows how long. So again, those are people I want to hear from. But you may say, okay, well, how does this happen? We see other areas that you don't see this happen. Well, you have to look at the contracts. You have to look at the contracts. And originally, a company called East Resources tended to be the company, was the company that secured a whole bunch of leases in Tioga, then sold those leases to Shell, and I think the number, and in SWEPI, the number I think was $4.7 billion. Let me say that again. East sold those leases for $4.7 billion to Shell or SWEPI. I'm not sure exactly how it went, but sold them for $4.7 billion. So now that's a lot of money, $4.7 billion. And look, that's fine. Hey, it's part of this whole system, and that's where we need to be educated and understand. Nothing wrong with that, nothing illegal, nothing like that. But we have to understand the system. So they sell it for $4.7 billion. Now, a guy named Terry Pagula was the owner of the company, and so he sold for $4.7 billion. And you say, okay, well, good for him. He made great business decisions. He subsequently, but he is also the owner of the Buffalo Sabres hockey team and the Buffalo Bills football team. And again, good for him. He made great business decisions, and that's what happens in the United States. That's capitalism. But at the same time, we can look and see what East Resources did and how they entered into these leases. They drilled these vertical wells. They held the leases and sold many of the leases, or sold the leases to another company. So wouldn't we want to make sure, and then that other company, now again, let me keep going here. The other company maintains these shut-in wells year after year after year. So you literally have thousands upon thousands of acres that are shut in where people never thought this was going to occur. So don't we want to prevent that from happening again? Well, of course we do. And there are ways that we can do that. There are ways that we can minimize the chance of that happening again. And there's actually ways that you could prevent it. Now, the question is, in the negotiation process, are you going to be able to do that? And with some companies, and I'm going to explain this as we go through, I can negotiate agreements, or clients enter into agreements that I know that will never happen to them. But there are some other cases and some other leases that I see that when you look at this all the time, I can say, boy, this lease gives the ability to have to this person and this landowner that can happen to them the same thing that's going on in Tioga County with these shut-in wells I'm talking about. So one such case that I think, and again, this is all my personal opinion, I think one such case is the JKLM lease. So I'm looking at this JKLM lease, which is being offered in Potter County now, and maybe some in Tioga, but certainly in Potter. So I look at this lease, and I go through, and I say, boy, this lease, in my opinion, really has a lot of loopholes in here that can create the type of situation that I see occurring in Tioga County. I see this type of situation. This has the framework of what I've seen before. So I'll look up, okay, who's involved in this company? It's a newer company. I do this across with any of the companies, especially if I haven't heard of them. And these guys have been around a while now, but lo and behold, look, Google JKLM, look at their structure and who's involved. And again, this is not bad. This is not, but Mr. Pagula is involved in JKLM. And again, this isn't nothing about him or anything that they're doing wrong legally. I don't see anything illegal about it. But what it is it's potentially the same type of business model. Potentially. I don't know. But I can see that it potentially is the same. So what do we need to do? We need to discuss that. We need to discuss, hey, there's potential here that in 10 years from now, you're shut in. In 15 years from now, you're shut in and haven't received any royalty. And there's terms and language that we can ask for that would prevent that. Then if we ask for it and the company says, no, we need to keep the lease the way it is, well, do we need to be concerned that what's going to happen to you is the same thing that's happening to other people that isn't a very positive thing? Well, we need to talk about it. And you need to think about it. We need to decide. And we need to see if we can change it to avoid those things. So those are just part of something that we would discuss. But I want to go into detail and explain what I'm talking about. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me each and every week at this time on this station for All Things Marcellus. And if you're looking for representation, you want to learn more about reviews, consultation services, regardless of your location, give the office a call, 570-307-0702. That's 570-307-0702. So you know what? I'm up against the break here. So I'm going to take the break here so we don't have to stop in the middle. And the next two segments are going to be heavily dedicated to explaining some lease terms and how these terms can be used to really extend these leases and how this type of lease could lead to the same situation as the people are experiencing in Tioga County with these vertical shut-in wells. And we can talk about ways that you could potentially change it. And if you can't change it, if the company says, no, we're not going to let you change that, then you need to ask why. If we can't prevent you from having the ability to shut us in and not produce gas for 15 years, if you won't agree to stop that from occurring, well, what does that tell us? That it may occur. And I'll explain. You're listening to All Things Marcellus. Make sure you join me each and every week at this time on this station. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Give us a call, learn about representation, see if we can help you. Reviews and consultations, all oil and gas representation, 570-307-0702. 570-307-0702, regardless of your location. All right, let's get into this. So, real quick, what we want to try to prevent is what's occurring in Tioga County and many, many places where people are being held because their leased property is included in a unit where there is only a vertical well drilled, which has been capped and shut in and is not producing. So, how do we prevent it? Well, I'm going to explain that as we go forward, but let me walk through some sample or some lease terms to show how this may occur in this particular case, which we're seeing in a JKLM lease in Potter County. So, this lease is a 5-year primary term lease, meaning that the company has to do something within 5 years in order to hold the lease, and that something is to conduct operations. And operations is a defined term, meaning that the lease itself will say you have to conduct operations, and operations include, and in this case, you have as broad as, if at the end of the primary term or any extension thereof, if the lease is not held in force by any other provision, and listen to this, but if the company is then engaged in making applications for necessary permits required for operation, grading or preparing a drill site, and it goes on and on. But what in the world is engaged in making applications? Does that mean your intern is filling out an application? Like, what does that mean, engaged in making an application? It doesn't mean the application is filed, or else you could say that. So that's a scary term, the one in which we want to try to define. Now, I have in many cases, and today, in recent times, I mean, within this week and pending to be signed, have leases that actually require, by the end of the 5 years, that the company be drilling a horizontal well, that they have to commence to drill a horizontal well, not a vertical, but a horizontal. So that means the permits are done, the permits are approved, the pad is built, the road is built, and they are drilling at minimum. They're drilling a horizontal well in order to maintain the lease. This lease says if they are engaged in making applications for any necessary permits or grading or preparing a drill site. Very different monsters there. Very, very different things. So what do we want? Clearly, we want a commitment to drill in a horizontal well. We do not want to be stuck like many people, unfortunately, who are being held by a vertical well that's shut in year after year after year after year, not producing. So one good way to try to do that is to require the commencement of a horizontal well, which is far more expensive. So when a company drills a horizontal well, they're going to be more likely to want to start producing from that well because it costs a lot to drill. It's a big investment versus a vertical well, which isn't nearly as expensive and is not going to produce nearly as much gas, not even remotely close. So that's one way. But let's go on more through this agreement. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So, okay, we're going to say this is a 5-year agreement, and let's say that the company has a 5-year option to extend this agreement. So, let's play this out as to what could occur. You could have, within 5 years, the company does nothing, and then decides, okay, we will pay you the same bonus rate again, and this lease now will extend to be 10 years. So now, at year 10, so you obviously haven't received any royalties, at year 10, let's say that the company is now engaged in making application for permits. So that means your lease doesn't end. So then let's say they go and they get their permit and they go ahead and they go on and they drill, and we'll say they drill a vertical well. Now they create a unit of 600 acres, 700, whatever it is, even though they've only drilled a vertical well, and they hold your property within that unit. So your lease does not end. One thing is, we want to get you a pew clause to try to prevent being held in part and being held forever by a small amount of your acreage. I'm not going to do it. We've done shows on pew clause, and I'll talk about those again, but that's just a way to defend it. But I don't want to get too sidetracked. So again, 5-year lease, they do nothing. They extend it to make it now a 10-year primary term, and at the end of the 10th year, they apply for a permit. Let's just say that within, I'll make this simple, let's make it easy math. We'll say within a year, they get their permit, they drill a well, now they have a vertical well. What do? They cap it, and they don't produce gas. So now, you have now hit year 11, and you now just, for the first time, entered into the shut-in phase of your lease. So, if you're smart, if you had a lawyer who knew what they were doing, you would have a shut-in limitation in your lease. And typically, a common number is 5 years. Sometimes we get 2, sometimes we get 3, but usually the worst we get is a well cannot be shut in for 5 years or more than 5 years. That's usually the worst we can do. So again, 5 years, they don't drill. They extend the contract to 10 years. They drill between year 10 and 11. Now, here we are in year 11, and they shut in your well. If you do not have a shut-in limitation, Companies will say, we can pay you, and say the shut-in fee is $5 an acre. We can pay you a shut-in fee of $5 per acre that we've shut in indefinitely. They argue they can do it for decades and never produce gas. So that's one possibility. But let's say you were smart enough. You put a shut-in limitation in there. Your lawyer put a shut-in limitation, negotiated to say you can't keep it shut in for more than 5 years. So how about this scenario? So you go year 5, nothing happens. They extend it to 10 years. 10 to 11, they drill a well. Now we're in year 11. They shut in the well. And so let's say they shut it in for 5 years. So now your contract is from year 11, you add 5 years, you're now 16 years out from the date you signed the contract. 16 years you're out. And you say, well, company, if you don't start producing by this 16th year anniversary, you're going to lose my lease. Well, what if this happens? What if in year 16, the company says, you know what? We're going to go ahead and plug this vertical well that we drilled. We're going to plug it. We're not going to produce from it. And you would say, well, great. Or, well, not great, because you just spent 16 years. You got 2 bonus payments, and that's good. But you have 16 years and no royalties, and now they're going to plug the well. And you say, well, all right, well, at least now maybe I'll do a new lease and I've learned my lessons, and we're going to get somebody that produces. So they plug in the well. Well, I say these companies are smart, and there's a reason why I say it. Because they are. And that's why these things aren't as simple as what, the landman would want to make it out to be, what the company would make it out to be. They're complex. It is very complex. So here's what happens. Listen to this language that's in this agreement. So this language is buried into a longer provision, and here's what it says. If at any time after the expiration of the primary term, this lease is not being kept in force by any other provision, the landowner agrees to extend the term 1 year beyond the completion of plugging operations of the last well on the leased premises, to permit another well. And if such operations result in the production of any substance covered hereby, this lease will be extended as long thereafter as production continues in paying quantities. So let me break that down to you. And to me, this is scary. So remember our scenario. They drill a vertical well at the end of 10 years. So it's completed at year 11. You're now shut in. Never received any royalty money. You're shut in because there is a vertical well that was capped and shut in, a vertical well. Now, year 16, you say, well, finally, I put a 5-year shut-in limitation in my lease, so finally I'm getting this off my back and I'm getting out of this lease. Well, the company says, hey, there's a well there, and we have now decided that we're going to plug that well, and we're going to drill a new well, a horizontal well. And then what they say is, you said, well, fine, but my lease is over. They said, well, no. Read the language, because what this says is, if there's a well, so there is a well, there is a vertical well. It's never produced, but it's a well, and it's out there, and it says that you have agreed in this lease to extend the term of your gas lease by 1 year beyond the completion of plugging operations of the last well. Well, just because it's one well doesn't mean it's not the last well. If there's only one well, that's the last well. So what if the company says, hey, we're now going to plug this vertical well that's never produced, but we're going to plug it. And because we are plugging the last well, which was the only well, we now get another year to drill another well. So again, doing our math, year 0 to 5, nothing happens. They pay an extension bonus. That's good. They buy themselves the year 10. Year 10, they apply for permits. By the time they're done drilling, it's year 11. Year 11 to year 16, you're in shut-in. Year 16, they plug that vertical well that never produced. Then they say we get another year to drill a new well. And that gives them to year 17. So now you have 17 years in this example. In this example, from the date that you signed your lease and you've never received a royalty payment. And then if they drill that new well, what are their shut-in rights? Remember, you were smart. You put a 5-year shut-in limitation. Well, if they drill and they produce and then they shut it in, now from year 17, can they drill, produce, shut in, and go out another 5 years, the year 22? I'm going to tell you, that's a long time. And you better be pretty young if you ever wanted to see royalties if this scenario occurs. Now, I want to say this isn't a guarantee that it occurs. No guarantee whatsoever. They could drill in year 1. You could be getting royalties. You could be rich as heck. You could be sitting on a beach in Tahiti. Or possibly you could be like the literally hundreds upon hundreds and hundreds of people in Tioga County at this time who are sitting there at vertical wells and shut in and not getting a dime of royalty but shut-in payments. I'm going to explain this more. I'm going to go over this again. But this is just to show how this can occur. And so what would we do? We'd want to address it, and there's ways to address it. And if the company won't address it, if they have to keep this language this way, then that should give you concern. That should give you, in my opinion, serious concern. So these are the keys where you need to identify these type of problems and then negotiate to address them. And if you can't address them through negotiation because the company won't change, you have to decide, do I want to enter into an agreement where the company has this type of flexibility? Do I want to do it or do I want to wait? Do I want to see if it improves? And those are other discussions that you need to have to figure out what's the best for you. Okay, I'm up against it here. I'm going to explain more of this. We're going to walk through it again here in the final segment. It's important stuff to understand that these things can occur, and that's the value of having reviews, consultations to identify this type of scenario so you're not in the same position. And I will guarantee you that those hundreds upon hundreds and hundreds of people in Tioga County wish they knew this information before they signed the leases that they signed, and they're sitting there year after year getting shut-in payments. But again, we need to stop it, and we're going to try. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. And as you probably guessed, I have not, do not, and will not represent oil or gas companies. I'll be right back. Remember, give us a call, learn about representation, reviews, consultations, 570-307-0702. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, give us a call, learn about what we do, see if I can help you. Reviews, consultations, and so much more. Any and all gas representation, oil and gas representation, regardless of your location, as long as the property or rights are in Pennsylvania, 570-307-0702. 570-307-0702. So, okay. So I have a short segment, as often is the case, because I don't want to, some of this stuff gets complicated and we don't want to cut it off in the middle. So again, here's the deal. What I'm talking about is that I see in Tioga County all of these wells, these vertical wells that have been capped and are shut in, and people are not receiving royalties year after year after year, and it makes me disgusted. So we want to try to prevent that. We want to try to prevent that and stop it for those individuals. You hear me talk about that all the time. And we also want to stop this from ever occurring in the future. And, look, back in 2000 to 2010, when people signed leases, they didn't know that this could occur. But now we know. Now we can defend against it. And I walk through how this lease could be used to prevent, well, could be used and could be developed such that royalties would not be received, potentially, and they're never a guarantee, but it could be, 15 to 20 some years before you see royalties. Now, I can't stress enough that I'm not saying that that will happen, but we need to make sure it doesn't. And so here's some different ways that you can do that and things that we negotiated. I, right now, today, have been negotiating and have obtained, and I've obtained for years from different companies in different areas, a provision that requires commencement of a horizontal well within that 5 or 10 year primary term, generally 5 years. Not all the time by any means, but several companies are agreeing to that provision at this time, which tells us they're serious about drilling. Quick little side note. Did a review and consultation this week. I talked to some clients and they said, yeah, the landman said they're going to drill 3 vertical wells. And the people were all really excited and they were going to start drilling in the next couple months. Well, we did the drilling records research and the permitting research, and lo and behold, what do we find? Only 1 vertical well permitted. So, yeah, there may be 3 wells in the future. Company may plan that. Well, you know what? I'm planning on going to Tahiti myself and sitting on a beach and drinking mojitos in my last 15 years of life. I don't know if that'll happen, but I plan on it. Really, I'm not planning on that exactly. But the idea of planning on something, what does that mean? It goes back to you can say anything. So, yeah, the people were under the impression, they're going to start drilling horizontal wells in the next few months, when in reality, no such wells are even permitted, but there is a vertical well permitted. So one of the things that we're able to do with certain companies today is negotiate a commencement provision that requires the drilling of a horizontal well to be started within that initial primary term. Then, I read from this lease that talked about that that would give them the ability to drill a vertical well, go 5 years and never ever produce from that well. And if you didn't have a shut-in limitation, they would go potentially, indefinitely forever, but we're going to try to stop that. But they drill that vertical well, they wait 5 years, and then they plug that well. It never produced, but it's still a plugging. They plug the well, and this lease says that gives them then another year to drill another well. And you need to be aware of this. So how do you prevent that? We'll say, hey, I want to get rid of this provision because I see what's happening in Susquehanna, or I see what's happening in Tioga County, and we need to get rid of that provision. So there's things that we can do, and we need to try to stop that. And there are others. And that's why I say reviews and consultations, we identify these things. We talk about these things. And again, I'm not saying you don't sign a lease, but you get the information. My clients tend to sign leases, but some of them elect to wait because there's good reason to wait. Or we maximize the agreement, and they've elected to sign at this time. But my heavens, guys, let's get you this information. Whether it's from me or someone else, let's get it to you from somebody who's working for you, whose whole goal is to help you to do the best that you can do. All right, I'm up against it. You've been listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, give us a call, see if we can help you. I do all the reviews and consultations myself. 570-307-0702. That's 570-307-0702. And remember, the landman works for the company, not you, the landowner. Let's stop signing bad agreements. Put down the pen, pick up the phone, give us a call, and most importantly, have a great, great week, everyone. See you next week.